Lecture 4, General Aspects of Criminal Law. The adversary system of American law. Some of the characteristics include knowing the exact charges against you, release on bond to help prepare a defense, protection from self-incrimination. In a trial, you don't have to take the stand and testify in your defense. Conviction only on a unanimous verdict, meaning that everyone must find you guilty in order for you to be convicted. Innocent until proven guilty, meaning that if the prosecution presents their side of the case and they're unable to come up with evidence beyond a reasonable doubt of guilt, the trial could be over at that point. Habeas corpus release if no evidence, meaning that facts, not speculation, determine whether or not you'll go to trial. No unreasonable search and seizures. And we talked about this earlier in lecture 1. Reasonable searches are allowed. It's only that unreasonable searches are not allowed. No double jeopardy, meaning that if you are convicted of a crime and you're doing probation and prosecution tries to recharge you on part of that crime, they can't. You've already been found guilty and sentenced. If you were acquitted, found innocent, then and later they find additional evidence, then they would still be unable to charge you with the crime again. Guilt beyond a reasonable doubt. I once took a class to a traffic court in Richmond, California, and there was a judge that was working that day, and he actually sat down and spoke to the students after he held his traffic court, and I asked him, how do you determine guilt? And he said, well, the basis is guilt beyond a reasonable doubt. I listened to both stories, and if there's a question in my mind whatsoever about whether the person is guilty, then I have a reasonable doubt, and I acquit them on the case. So that's what you need to think about. If there is a reasonable doubt in your mind that it's possible the person didn't do it, then you shouldn't vote on a verdict for guilty. Public trial. Everybody has a right to a public trial. That's another one of the characteristics. The exclusionary rule, which the exclusionary rule goes along with unreasonable searches. If police find evidence illegally, it's to be excluded and it can't be referred to at all during the trial. Examine and cross-examine witnesses. If someone's going to come up and testify against you, you have the right to challenge your testimony. Legal representation. This goes back to a number of different cases, one being Gideon versus Wainwright. Legal representation has been something we've had to fight for a long time. Currently, if you can't afford an attorney, one will be appointed to you through the public defender's office. Another characteristic is fair trial with numerous legal rules. Due process is the big thing here, making sure that it's fair. Trial before your peers, finding impartial persons to make a decision on your case, and appeal convictions but not acquittals. If you're convicted, you can appeal it all the way up to the U.S. Supreme Court. If you're acquitted on a case, that's it. Prosecution can't go after you a second time. Functions of a judge. Judge and jury functions are separate from that of an advocate. The judge should be neutral. They prevent the presentation from becoming disorderly. Now, I'm going to read the following, what's on the slide, but then I'll try to give you a couple of examples. In a jury trial, they can't make comments on questions of fact, meaning guilt or innocence. In a bench trial, they handle questions of fact. And we'll talk about this in a second. And they make comments on decisions on questions of law in all trials. And they're supposed to ensure no violation of your rights. Now, think of it this way. If you have a jury trial, the jury is the one making the decision on guilt or innocence or questions of fact. Did the person do it? The judge can wear two hats here. They always wear the hat that deals with questions of law. Is the search legal? Is the admission of evidence legal? Is the admission of the testimony of an expert, is that person qualified? The judge makes all those decisions. Now, as far as questions of fact, That's a separate hat that they could wear in what we call a court or bench trial. In a bench trial, the judge hears the case. You do not have a jury. Now, you have the right to have a jury, but you can waive it. Why would somebody do that? Well, let me give you an example. If there's a case that's very politically motivated, you may want to go with a court trial or bench trial and let the judge make the decision on your guilt or innocence, because they're going to be less emotional. They're going to look directly at the facts. An example would be in a case called the Malice Green case. There were some officers that were fighting with a drug dealer, and the drug dealer died in their custody. Now, 5 people were charged on that case, very politically motivated. The community was very upset. And 2 people that were charged were a rookie and a field training officer who arrived at the scene after the suspect expired. And don't ask me how they got prosecuted on this case, but they ended up in court. They opted for a bench trial, and they went before a judge, African-American judge, who immediately acquitted the case. He looked at it, said, that's it. So that would be a situation where you would probably want to go to a bench trial. Most of the time, the advice from attorneys that are friends of mine is that if you are innocent, go to a bench trial. It'll be quick. The judge will see what's going on, look at the evidence, and find you innocent. But if you're guilty, you're better off going to a jury trial, because a lot of games can be played, and if you can raise a reasonable doubt in the mind of the jurors, you can get off on the case. The judge maintains control in the courtroom. Attorneys are kind of like actors. If you've ever gone and watched the People's Court or Court TV, you see that they do things to influence the jury. A great example would be Judge Ito controlling Johnny Cochran and dealing with the whole media circus of the O.J. Simpson case. Very important that the judge maintains control. I can remember Judge Ito turning off cameras when they zoomed in on a pad where O.J. was writing some notes to his attorney, or one of his attorneys there, and Judge Ito felt that on TV they would be able to see this communication between the attorney and client, and that violated his rights. So judges maintain control in the courtroom. In other countries, judges do, the way that they run their judicial system can be much different than ours. In England, the judge gives a summary to the jury regarding defendant's guilt or innocence. In other countries in Europe, you have an inquisitor type system. Means that you don't have a jury. I mean, we're pretty spoiled here. We have juries and we have a lot of rules. In some countries, they'll have judges, maybe 3 judges will sit. There'll be a main judge and 2 others. They each get an equal vote, and they listen and they question, and they make a decision on your guilt or innocence. Why defend a person that might be guilty? Well, I've asked this question of a number of attorneys too. Sometimes it could be the only way to bring out facts in a case. Sometimes defendants think they may have committed a crime when in fact they didn't. Or one of the big ones is the defendants admit guilt to protect others. Someone else actually committed the crime and they're protecting them. Also, sometimes defendants are mentally unstable and say that they're guilty and they actually didn't do it. Juvenile court. Juveniles are treated totally different than adults in California. As a matter of fact, we always talk about, we don't really arrest juveniles, we detain them. And the judges that work in juvenile court are specially trained. They get additional training compared to a regular judge. Accusatory pleadings are called a petition. If a petition is upheld, it's not a conviction. They say that it's adjudicated. Before 1968, a probation officer was both the prosecuting and defense representative. But in 68, a case where a young kid named Galt was arrested and prosecuted basically said that even though I'm a juvenile, I have the same rights to an attorney that anyone else does. And this resulted in a more adversarial system. After that, you had defense and prosecution. Plea bargaining. Definition of plea bargain is that the prosecutor allows the defendant to plead guilty to a lesser offense or degree of crime in return for saving the state cost of time or a long trial. So you plead guilty in consideration. Career criminal program. I bring this up because in the early 80s we had the CCAP program. That was a career criminal apprehension program. And it did a lot of things to the criminal justice system in Northern California. One of the things was that we began to computerize records and systems. We started to use computer-aided dispatch systems. We had a computer link between the county jail, the local police departments, the district attorney's office, and we shared banks of photos. We shared criminal history information, and we were able to look immediately and see where at what point was someone who had been arrested. Were they ready to go to trial? Were they in custody? Where were they in custody? Did they have priors? Were they released on bail? We could look all of these things up and know what was going on with a particular person in a particular case. One of the things that happened with the CCAP program was we were able to do crime analysis also. And we used a program called Land Tracks. Now what happens is, as calls are called in or crimes are reported, and officers take reports and verify that these crimes are reported, all this info goes into a computer. You're able to sit down now and, using Land Tracks, pull up a map of the city and identify your area that you will patrol, usually what we call your beat. And you could ask Land Tracks to give a yellow X for every auto burglary that was occurring on your beat and when they were occurring, and it would show, and it would give you a time, and it would give you the days of the week that most likely they were occurring. You might have a situation where a burglar is doing auto burglaries and they are they do it on their nights off like everybody else. It's a side job. And so this would help you to catch that criminal. Another part of the career criminal program was vertical prosecution. Teams were made up that once someone was identified as a career criminal, then teams were made up of prosecutors who would be assigned to that particular person. Normally what would happen is, as a patrol officer, you'd go out, you'd make an arrest, you'd write a report, and the next morning you get it to the desk of the district attorney. The district attorney reads it, and it would be the local district attorney from that office that you're at, and they would handle the case. Now the defendant would try to work out a deal with that person. If they weren't able to cop a plea and do a good plea bargain, then they would wait until they went to the next level, which would, if it's a felony, would be Superior Court. Now in Superior Court you get a different attorney, and they may give you that deal or may not. In vertical prosecution, what happens is, once that prosecutorial team finds out that a career criminal is in custody, they actually show up for the first hearing and show up in front of the judge for the preliminary hearing. They show up for the arraignment, and they show up for the trial, and they prosecute the trial. No plea bargains are given. Smaller caseloads for these prosecutors in that program. And what started to happen was that plus 3 strikes, we started to see career criminals go to jail. The purpose of the criminal law. Protection of life and property. This is a throwback to Hammurabi and the Mosaic Code. Protect life and property from the dangerous individual. Protect the weak and the sick. Crimes are prohibited and punished on the grounds of public policy to prevent injury to the public. Injury to the public may include destruction or interference with the government, human life, private property, or other valued institutions or interests. Such considerations as desire for vengeance or compensation for injury may also be involved. Punishment is often said to be the purpose of criminal law. This is true only to a point. The real purpose of the criminal law is to define sexual intolerable conduct and to hold conduct within limits which are reasonably acceptable from the social point of view. and that could vary from each region. The law establishes peace and order. It defines and regulates behavior and controls violent behavior. It resolves problems in a fair and just manner through established legal procedure. It can resolve everyday problems in a fair and just manner, and general law and the way trials are conducted are established as a rule based on constitutional protections. It can prevent crime. You know, if you know that you're going to go to jail, you may know that you can make a lot of money in selling crack cocaine, but if you get caught with a large amount, you could go to prison for the rest of your life. And that's a deterrent. Knowing that someone can be punished is thought to be a deterrent. The law established predictability based on expected behaviors of others. Examples could include expecting that drivers will stop at stoplights. Boy, where would we be if people didn't pay attention to traffic control devices? Expecting drivers to stay on their side of the road. The law also preserves moral and social behavior. You have a variety of different sorts of laws, like no smoking, no sex with minors, no alcohol in certain states. We also have victimless crimes, which would be drugs and prostitution. And these are changing on a day-to-day basis. As I'm doing this lecture right now, there's been an initiative to legalize marijuana for medical purposes, and there's an initiative right now which is gaining popularity that may legalize prostitution. Gambling has changed also, so as society changes, so do these different laws. Preservation of freedom and liberty. States versus Watson. This case talked about the law is not only to protect the public from the criminal, but also to prevent the conviction of the innocent or prevent the conviction of a person whose guilt is not proven beyond reasonable doubt. The system is not perfect. In order to release the innocent, some guilty are going to be released also. I don't think when our system was set up that our forefathers understood the magnitude of the crime problem that we have currently, but it's still the best system in the world. Prevention of anarchy or illegal interference with the government. Without the law, the government couldn't protect itself. Although we don't believe in all the policies that come out of our government, sometimes it's still the best government in the world, having a democracy, and we have to protect that. And so we have laws that do that. Rules controlling the language and construction of penal code statutes. All California law is statutory. In other words, if it's on paper, you have a prayer. If it's not on paper, all you have is error. It has to be written. We have to be able to look at it. The statutes must be in English. Must be in English. No statute can be too vague, broad, or uncertain. In other words, it can't be misinterpreted. One officer can interpret it one way, another officer interprets it another way. If it says failure to stop at a red light, that's pretty clear. If it says that you're going beyond a posted speed limit, that's pretty clear. Statutes can denounce a series of acts like littering. Littering could include things like dumping, burying, discarding. You may see a variety of different descriptions of actions that are included in that. Also resolves conflicts between statutes. Law of preemption. We've already covered law of preemption in a previous lecture, but again, it's a U.S. Constitution is the top law on the line, followed by federal laws, followed by state constitution, followed by state laws, and then local city ordinances, local, county, and city ordinances. Also, if there's conflicts between different levels of government, again, we have preemption. You may have a conflict between two different areas. For instance, a city may try to enact a tax on alcohol, and the state is the one that already has the tax on alcohol. They're in control of it. We also have special acts or bodies of laws like dangerous weapons laws, alcohol beverage control laws, Uniform Controlled Substance Acts. Now, one of the issues that we're having right now is that medical marijuana is being challenged by the U.S. Attorney General, saying it's in violation of federal law. That's California law, so by preemption, it would be preempted by the federal law. In fact, the discussion gets pretty deep, because if you're going to say that marijuana is legal, then it has to be approved by the Food and Drug Administration, which means they have to do some sort of testing on it so that you know what is in the marijuana, what type of herbicides are in there, what is the content of the THC, which is the drug that actually acts on the brain with marijuana. All of these things have to be answered, and at some point they will be. Interpretation of how the law is written. Corpus Delecti, body of the crime. Elements of the crime. Corpus Delecti is Latin for body of the crime. The elements of the crime are act and intent. California law establishes that you cannot arrest someone unless you're able to establish that the elements of the crime are there. And we're going to be looking at a penal code section in just a second. I want you to think, though, about when you look at elements of the crime, think about a milk stool. A milk stool has 3 legs on it. If one of the legs breaks, then it won't sit up on its own. You won't be able to sit on it. You'll fall down. That's how you should think about elements of the crime. Now we're going to look at a sex crime, so it's pretty graphic. I'll give you a little warning here. This is PC 289. Penetration of genital or anal openings with a foreign object. And the reason we're using a sex crime is because I want to show you that there are many different circumstances that will give you the probable cause to establish the elements of the crime. So let me read the general description here. Every person who causes the penetration, however slight, of the genital or anal openings of any person, or causes any person to penetrate the defendant's or another person's genital or anal openings for the purpose of sexual arousal, gratification, or abuse by any foreign object, substance, instrument, or device, and one of the following circumstances. Now, we go to the next slide, you'll see there's a whole list here. 289A, against the victim's will by force, fear, or retaliation. B, victim incapable of consent due to a mental or physical development. D, victim is unconscious. E, victim drug intoxicated. J, victim under 14 years and the perpetrator 10 or more years older. H, victim under 18 years of age. I'll give you an example. We have a certain pop star who likes young boys, and if he were to penetrate a young boy's anal opening with any object or his finger, anything other than his genitals, and that child was under 14 years of age, and this person's around 40, then we would have that 289J statute. If the victim was drugged or intoxicated or was asleep at the time that the assault occurred, then we would have 3 separate sections. We'd have D, E, and J. And if the victim's under 18, which we already know, we'd have D, E, J, and H. And if the victim suddenly woke up and tried to fight this attack and was restrained, we'd have A, D, E, J, and H. So in one instance, you may have multiple crimes that have occurred. So the elements of this crime are foreign object penetration, however slight, genital anal openings, specific intent to cause sexual arousal, gratification, or abuse. So in this crime, it could be where somebody's torturing another person. There's no sexual arousal to it. They're trying to hurt the person. Where it's accomplished against a person's will by means of force, violence, duress, menace, or fear of immediate or unlawful bodily injury. This is a felony. Some of the definitions. Foreign object includes all instruments, substances, devices, or parts of the body except sexual organs. I once investigated a case where a very sick individual was abducting prostitutes and sticking the barrel of a handgun into their genital opening and pulling the trigger. It was empty, lucky for them, and we eventually caught him. This would have fallen under this case. Threat to retaliate. A threat to kidnap or falsely imprison or inflict extreme pain, serious bodily injury, or death is under 289.1, and they do the assault. And last, consent is a positive cooperation in act or attitude pursuant to the exercise of free will. On many of these cases, the first thing you have to do is see if the person is of age, if they can give consent, and the next thing is or they had a mental deficiency that wouldn't allow them to give consent. And the second thing is did they give consent of their own free will? Menace. Another definition will be associated with this penal code section is any threat, declaration, or act which shows an intention to inflict or injury upon another person. When we look at menace and duress, same thing, it's where there's a threat of force. If the person has the other person scared that they allow the act to occur out of fear, it fits this description. Punishment 3, 6, or 8 years. Statute of limitations, which we'll talk about in a later chapter, is 6 years. That means that the case can be prosecuted within 6 years of the occurrence. Ways to prove corpus delecti. By direct evidence. Direct evidence is witness testimony. Witnesses use their 5 senses to observe the act. The witness describes fear or some other necessary element. Witnesses are allowed to testify, even if you're not an expert. You're able to testify about things that most people can make judgments on, like if a person was going fast for the traffic conditions, if a person was angry or they were sad, or did they smell of alcohol. Those sorts of things someone could testify about. Circumstantial evidence, that includes fingerprints, photographs, videos, DNA. This is something that tends to prove guilt, but may not always convince a jury. Admissions and confessions. Now, you must have the elements of a crime first, and then these things can help you with your case. In other words, Crazy comes in and says he killed 23 people over the past 10 years, and you have no information on missing persons that back up the story. Someone's just giving you some information. They could be totally nuts, and you need to be able to have elements of the crime before you could charge this person. Admissions are different than confessions. Admissions is where somebody says something that's, against their penal interest. It's something where for instance, we have a shooting and there's a 9mm used, and a person says to you that they own a 9mm pistol. Well, that's an admission, but that is not a confession. The confession would be where they come to you and they admit guilt in the case. Yes, I did it. I did the shooting. Rules controlling the conviction of criminal acts. Burden of proof. The prosecution has the burden of proof for to show that beyond reasonable doubt that the defendant committed a crime. On insanity, now this is interesting because in insanity the burden of proof goes back onto the defendant to show that they were crazy and were not able to form criminal intent to commit a crime. A preponderance of evidence. If we start to look at different levels of evidence, we start at a preponderance. That would be, if we have a scale of 1 to 10, that would be about a 5. Clear and convincing would be about a 7, and beyond reasonable doubt would be like a 9.5. Presumption of guilt. It's presumed that we're innocent until proven guilty. Again, we've talked about reasonable doubt before. Reasonable doubt deals with the fact that if in the juror's mind there is a reasonable doubt that the person may have not committed the crime, that they shouldn't vote guilty, a guilty verdict on them. Convictions only from unanimous verdicts. We already spoke about that. All crimes are against the state, and the reason for that is that if the victim is dead, the state steps up and represents them. Questions of fact and the law. When we talk about questions of fact, we mean who did what. When we talk about questions of law, we mean what is the law. In a jury trial, the jury handles questions of fact. In a court trial, the judge handles questions of fact. This is kind of just a review. Legal requirements for citizen action when a crime occurs. In other words, do you have to respond when there's a crime in progress? Well, the state encourages you to take action. As a matter of fact, if a full-time peace officer requests your assistance and you go to help that person and you get injured, you're eligible for workman's compensation under posse comitatus. But there is no requirement to enforce the law. Number one, citizens may not understand the corpus delecti, the elements of the crime, or you may be injured or handicapped or scared. There's no requirement to assist. There is a maximum $50 civil fine. Key terms for this lecture: adversarial system, function of judges. You need to know those. What do the judges do? Plea bargain, career criminal program, the CCAP program, purpose of the criminal law, language and construction of penal statutes, legal requirement for citizen action when crimes occur, preemption, the letter of the law, the spirit of the law, corpus delecti, direct evidence, circumstantial evidence, admissions, confessions, and rules controlling the conviction of criminal acts. This is the end of Lecture 4.